Good afternoon. We have almost 7 hours of argument time requested. We are familiar with the briefs in the record, so only ask for the time that you need, not the time that you wish. If we have further questions, we will definitely keep asking them. People versus Khan is submitted. Angelino versus New York City Department of Health. Are you the appellant? Yes. And how much time are you requesting? Is the respondent here? Okay, normally if the respondent's not here, we just submit it, but since you are here, we will give you 3 minutes to argue it, okay? Raphael versus Kimberly is submitted. Green versus Whole Foods Market, appellant? Respondent? How much time are you requesting? 5, 1, and 5. 200 Claremont Avenue versus Estate of Elsie Lewis. Okay. 3 minutes. 320 West 87th versus 320 West 87th Street, appellant. Respondent? Yes, 3 and 1 and 3 and 1. People versus Ruiz. 4, 1, and 4. People versus Sosa is submitted. SF Consultants versus 28 West Group is submitted. Hinkson versus New York Presbyterian, appellant. Respondent? 5, 1, and 5. People versus Valgayan, appellant. 5, 1, and 5. City of New York versus Board of Collective Bargaining, appellant. Are there 3 parties on this? Respondent? Do you have a cross appeal? 5, 1, 5, and 3. Boliak versus Riley, appellant. Respondent? There's only 1 brief, though, right, in opposition? 2 briefs? 5, 1, 5, and 3. People versus Rivera is submitted. People versus Quinones is submitted. Joseph versus Memorial Hospital, appellant. Is the respondent here? 4, 1, and 4. People versus LaFleur, appellant. Respondent? 3, 1, and 3. Plotch versus Citibank is submitted. Davis versus Port, appellant. Respondent? 5, 1, and 5. Yeah, 5, 1, and 5, 1. And the first case on for argument is Angelino versus New York City Department of Health.
May it please the court, Your Honor, my name is Eli Angelino, petitioner pro se. Your Honor, the respondent opposition is in an attempt to evade the fact by claiming this case is frivolous. I must respectfully remind the court, this court already verified the underlying merits by granting my motion for leave to proceed as a poor person. The appeal is meritorious. The city has committed a proven crime to obstruct the record and illegally sanction a New York resident. The evidence is secured and irrefutable, supported by 3 independent proofs of Manhattan birth: the hospital letter, the baptismal certificate, and the California court order. The only appropriate remedy for this proven criminal misconduct is a $10 million sanction requested in Motion 36. Beyond sanction, we respectfully ask this court, honorable court, to reverse the judgment below, compel the respondent to execute the ministerial duty of correcting and releasing the appellant official birth certificate, and to immediately release the complete application and money order records, Exhibit AE, which they currently retain. And for this reason, Your Honor, the appropriate remedy for this confirmed act of government fraud is to reverse the judgment below and immediately levy the requested $10 million sanction against the city of New York. I thank the court for its time, Your Honors. The city defense is a desperate chronological lie. If the petitioner, who has twice proven the city default to your satisfaction and secured the evidence of the city perjury on your public docket, cannot find justice and relief in the appellate division, where in the state of New York does justice actually reside? Your Honor, I have a 3-point, the legal merit. Your Honor, the lower court committed a legal error by penalizing me for the necessary defense of my due process right while ignoring the city documented pattern of official or fictional litigation. The city failed to introduce the legal fiction until after I filed the California court order, proving their defense is a desperate lie, not a legal truth. The second merit is a baptism certificate. Your Honor, the city argument is irrelevant and futility trap. The certificate is one of the 3 independent proofs, and it confirmed the foundational fact the city denies: my birth in Manhattan, New York. Furthermore, the city on record confirmed my existing under the name unknown family, proving they are concealing the civil record, not missing it.
I'm going to interrupt you. Your time is up, but we have your briefs, we have the record. We're going to look over everything very carefully, and thank you for coming today.
Your Honor.
Thank you. Green versus Whole Foods Market.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant. In this case, defendant's motion was built on inadmissible hearsay and lack of personal knowledge. The only witness they produced, Ms. King, admittedly has no personal knowledge, and she admitted that she was the wrong witness. I've never seen anything like that
Not
before.
even really arguing that anymore, are they, that there was a sufficient documentary proof submitted about the inspections or testimony to support that there was a regular schedule of inspections? That's not even an argument they're pursuing in their brief, is it?
No, they never made that.
Okay, so,
Well, I mean, they are claiming that that they established lack of constructive notice, but they didn't. So because Ms. King was produced and has no personal knowledge, and she testified about this inspection log, right, this Gleason log that's at 440 of
right,
the
but
record.
that's what I meant. They're not really pursuing that the inspection logs were sufficient to support their summary judgment motion in the appellate brief.
Right. Our position is the log is insufficient.
Right, but they're not even arguing anymore that the log is sufficient, I'm saying. So that doesn't seem to be their primary argument anymore on appeal.
My understanding in their brief, my reply brief, I addressed the log, but, I mean, we could talk.
You might have addressed it, but all I'm saying is that was not the primary argument they're making on appeal anymore about the logs.
Their position is that the log established that at 9/12 was the last time it was inspected, but it wasn't.
Okay,
So,
go on.
okay, let's assume they're not saying that. Then they're saying that.
Counsel, the bottom line is your client, the plaintiff, based on her testimony, based on photograph, established she came in to a pigsty in that bathroom.
Correct.
She went to the bathroom, she came out, the water that leaked from the bathroom
Correct.
was the accident, and they really have nothing to counter that.
Correct. I mean, I think, Judge Kern, if maybe what you're saying is that their angle was that the water, and they misrepresented in plaintiff's testimony that the water or liquid that was on the floor had come into existence within 10 seconds. It was a theory that they fabricated. The 10-second has nothing to do with how long the water was on the floor. What the plaintiff testified to is she had never seen the water prior to her accident, and that she took a different path to the toilet than she took to the sink when she fell, and that even if the water emanated from the toilet, that's on the defendant. It's their bathroom. They allegedly were supposed to, according to the log, which maybe they're not taking a position on, there's no evidence as to when this was last inspected, whether they maintained the bathroom in a reasonable condition. And in addition to that, Ms. King testified, in addition to the log being created by some imposter that we don't know who it is, that after the Gleason procedure was supposed to be done, she, as a supervisor, was supposed to check to see that the Gleason procedure and the Gleason was properly done in the bathroom. So between 9/12 that the trial court's the one that hung their hat on this 9/12 inspection, which there's no proof that it occurred. But then from 9/12 to when the store closed at 11, there should have been, according to Ms. King's testimony, who again has no personal knowledge, is that
She doesn't even remember if she worked that day.
that's correct. She has no recollection. But she was supposed to, somebody, if not her, then another supervisor was supposed to check the bathroom at some point before it closed. So the photograph at 241 of the record in plaintiff's testimony refutes any testimony by Ms. King that this bathroom was tended to and inspected and maintained and cleaned after the last Gleason inspection at 9/12, because you see at 241 of the record that the bathroom is completely neglected. I could take anything else up on my reply unless you have any questions right now.
Thank you.
Okay, thank you.
Your Honor, may it please the court.
So it's your burden to show that you lack constructive notice, right? That's what this appeal comes down to. How did you establish that you lack constructive notice?
Yes, Your Honor. Notwithstanding your respected opinion that you may have formulated based on the record in this case, and notwithstanding the appellant counsel position, this appeal turns on one simple and disputed fact. When the plaintiff enters the restroom that was discussed where the accident occurred, the floor was dry.
But how do we know that? Because the mere fact that plaintiff didn't see the water doesn't mean it didn't exist. So how, other than pointing to gaps in plaintiff's proof, what evidence have you submitted that establishes that the floor was dry when the plaintiff entered it, or that you're entitled to summary judgment?
Your Honor, yes, we are conceding that the bathroom was cleaned on 9/12.
No. So the question is, what proof is there in the record to support your claim that the bathroom floor was dry when the plaintiff entered it, other than that the plaintiff didn't see it?
Your Honor, the plaintiff's own testimony clearly showed that the bathroom was clear.
Well, all that the plaintiff's testimony shows is that she didn't see it before she fell. We have never held that by itself is sufficient to make out a prima facie case for summary judgment on the defendant's part. So what other evidence is there other than the fact that plaintiff didn't see it to support your argument?
Your Honor, again, I keep going back to the plaintiff testimony because the plaintiff did not show any.
The plaintiff has the floor being wet.
There is no facts or evidence to show where that water came from, and was it?
Well, isn't her testimony evidence? I mean, she says when she fell and when she got up, she was wet, and when she went in, she was dry. So that leads to the conclusion that the floor was wet. So how do you establish that you lack constructive notice of that wet condition? Or if you establish that, well, she's telling a story, but you don't have any evidence that she's telling a story.
Well, Your Honor, if the bathroom was not cleaned, if she entered, she would have, when she entered, she would have, there is no footprint, there is no water tract, there would have been some sort of sign that
When she gets up, she falls, and when she gets up, she finds that she's wet.
Your Honor, she testified under oath that she observed the water on the floor only after she flushed the bathroom, which is 10 seconds after she uses it.
So when
Your
did she
Honor,
fall? When did she fall? I mean, when did she fall that she gets up and she's wet?
Your Honor, if you look at the records, the sequence of events that indicate the water appeared that when she flushed the restroom, that's when the water.
I mean, the evidence that's in the record shows that the pictures show that the bathroom is not in good condition. So it hadn't been, there's this claim that it had been inspected at 9:12 p.m. that's not, doesn't really get supported by the record when you see the garbage condition in the bathroom.
Your Honor, she's not claiming that the garbage is what caused the condition.
We understand that, but that goes to the subject of your inspection.
Your Honor, you could have mopped the toilets and not removed the trash. The bottom
No,
line
but I
is
mean,
not-
the point is, how did you prove that you did that?
Yeah.
What did you put in? It's your burden. Has nothing to do. The plaintiff at trial, I hear what you're saying, you're going to argue that. What did you put in, regardless of the plaintiff's burden? What did you put in to show your entitlement to judgment to dismissing the complaint? The only thing that I saw were incompetent reports that are not in evidentiary form, and a witness who said, I don't know anything about this. That's your entire case in support of your motion for summary judgment. That doesn't get you, that doesn't show that you didn't have constructive notice. Regardless, if plaintiff says I didn't see it, that doesn't meet your burden of showing lack of.
Your Honor,
What do you have?
Your Honor, let's assume that the restroom was cleaned.
No, I don't assume. I want you to tell me what you have to show that you didn't have constructive notice.
What I have is that the plaintiff testimony, Your Honor, indicates
it?
that that's.
Okay.
Okay.
Thank you.
You're welcome, Your Honor.
I mean, just for a second, the only evidence before the court was plaintiff's testimony in the photograph. There is no evidence to establish a lack of constructive notice because they don't have anybody that has knowledge.
Did the plaintiff ever testify that she was 100% certain that the floor was dry before she fell?
No, and there's no evidence of that. In fact, no, the answer is no. She never testified
She
that.
said she didn't see the water.
She didn't
right?
see the-
Which, I mean, maybe she's not looking down.
Of course.
Right? And therefore, that could be exactly why she didn't see any water on the
Correct.
floor, right?
And Your Honor, as she testified at 214, that she took a different path. So she may not have seen any water that she then eventually slipped on from the toilet to the sink, but she entered from the door to the toilet. So there is nothing on this record to establish that, nor does that's not plaintiff's legal burden to establish whether she saw it or not before. As we know in Porco, your case in Porco, the plaintiff, it doesn't establish a lack of constructive notice on the defendant's part if the plaintiff doesn't see it before she falls. If she saw anything that resembled liquid or water, I presume that she would have stepped around it and not fallen on it.
Thank you very much.
Thank you very much.
200 Claremont Avenue versus Estate of Elsie Lewis.
May it please the court, Appellate is asking this court to find that the 2019 version, the revised version of the RPAPL 711, in a case where a tenant has died, what the landlord's remedy is for non-payment. We're asking this court to find that it did not abolish 50-plus years of practice and
Why should we find that? Because you look at what it looked like before the HSPTA, and it specifically allows you to commence an action without an executor after 3 months from the date of death if an executor is not appointed. And then you look at the new version under HSPTA and TPA, that language is gone.
That language is gone.
So that was a conscious decision, obviously, on the part of the legislature to take out that language since it was in the original version. So how else should we construe it other than that was their intention, that that would no longer be a remedy?
because they reinstated they made a different provision. They didn't say, after serving the executor. What they said is, you're now serving a different party, not an executor and administrator. In the old version, you served a spouse or a family member who didn't have to live there.
It specifically says.
Now you serve the
that
occupants.
It specifically says that you have to get a judgment against the estate, and there's longstanding law that you can only get a judgment against an estate if you sue the estate, which you can only do if there's an executor or an administrator. So it seems pretty clear, once they say you have to get a judgment against an estate, that the only way to do that is by suing the estate.
A different housing court judge than the one whose decision we're appealing here, Judge Chinea, found that these are in rem or quasi in rem proceedings.
Okay, how many years have we all agreed that shares in a proprietary co-op corporation are personal property? I don't know where that came from, but it is well established.
It's not real estate, absolutely, but
Right.
it's
No, it's nothing. It comes out of the thin air. It's real property. It's personal property, rather. And we've all known that for 50 years.
why?
So
why does
forget
the-
about that lower court decision.
Okay. I'm asking, why would the new law says that you commence the proceeding, you don't serve the estate, if there is no estate, you serve the occupants. And yet you
But
get
it
a
also
judgment
says
against the
it al-
small e estate.
Yes, but you can only get the judgment against the estate, which was not there in the old section of it.
I'm asking, why would you need this law at all?
I mean,
If you have- once you
if I
go-
was the legislature, you can ask the legislature that, but I can only tell you what the statute says, and the statute says that you can only get a judgment against the estate. You can only get an estate judgment if an administrator has been appointed, right?
You're
That's
going
it.
against a long-established rule that if you're suing an estate, there's got to be an executor or an administrator,
There was a long-established exception in this law.
which was eliminated.
Well, not expressly.
Thank you. Thank you.
Thank you, Your Honor.
320 West 87th versus 320 West 87th.
Good afternoon, Your Honors. May it please the Court. My name is Jerry Weiss, and I represent the appellant, cross-respondent 320 West 87th Street, in this matter. Your Honors, we respectfully submit that the motion court incorrectly declared and recognized the respondent as a holder of unsold shares in light of the fact that the respondent as an LLC entity cannot qualify for holder of unsold share status under this offering plan. The offering plan defines a holder of unsold shares to be financially
Counsel, assuming that you're correct in your argument that an entity couldn't have been the holder, what about the waiver argument that for 2 years, there's no question that they were treated as the transferee of the sponsor in every way, shape, and form, including getting 2 seats on the board? Why shouldn't the court find, under these circumstances, then, that as a matter of law, a waiver of that argument has taken place?
Your Honors, respectfully, the deficiency in the LLC as a sponsor, as opposed as an entity, the deficiency in the LLC being an entity is not something that the cooperative can waive. That's what the governing documents say. The governing documents say it's got to be an individual.
I don't understand deficiency. The LLC was stepping in the shoes of the sponsor, who was an entity. That was the original, just hold the thought. It was an entity that was the holder of unsold shares, managed to keep everything under the 20% rule, so that everything was good. We have an entity now, a successor LLC that's coming in, or a successor entity that's coming in to take over the remaining shares, pay maintenance when that entity was losing money every month by virtue of the fact that the rents were lower than the maintenance, paid a premium, and managed to keep the income going for the co-op. And for 2 years, you folks were fine as a successor sponsor taking over. There was a clear waiver here based on the actual conduct of the board.
Your Honor, I don't want to interrupt, but I would essentially, initially, I would refer you to the decision in this court's decision in Rotblut, in which the court made sure to say that the fact that the cooperative may have consented and had charged certain fees did not demonstrate a waiver.
Didn't you go a little bit more beyond just consenting? You affirmatively did things. Your shareholder meeting recognized them as being an entity that had these rights to the unsold shares. You had a notice to shareholders which indicated that you were treating the petitioner as a holder of unsold shares. So you affirmatively did things recognizing this entity as a holder of unsold shares.
If I may respond, Your Honor, I see my time is up.
You can respond. Go
Thank you. Your Honor, again, we have an offering plan which was drafted by a sponsor. The sponsor carved out for itself the right, despite the fact that it was an entity, that it can become a holder of unsold shares, but specifically said, and probably because the law at the time this offering plan was drafted did not permit it to become an entity, but it had every opportunity to amend its offering plan and to include and to broaden and expand the scope of who may be an offering plan. It never did.
Thank you.
Your Honor, thank you.
Your Honors, John McCarthy on behalf of the Respondent Cross Appellant 320 West 87 LLC. The reason why they didn't amend the offering plan is because there was no need to amend the offering plan. And the best evidence as to what the sponsor who drafted the offering plan believed its offering plan provided for is the written designation of my client as successor holder of unsold shares.
Doesn't the offering plan, responding to what you're saying, doesn't the offering plan itself state, though, that the offering is made only to individuals and not to corporations? So doesn't that create a problem with your argument that, that an entity could become the transferee?
No, Your Honor, because that, first and foremost, the general provision is talking about who can become a bona fide purchaser for occupancy, not who can become a holder of unsold shares.
For 3 years, right? And then after 3 years, it's silent.
Correct. There's no
Right.
prohibition. What it does say, it does allow the sponsor entities to continue as holders of unsold shares after the 3 years. So the definition of holder of unsold shares in the offering plan always contemplated.
Well, at a minimum, it's not unambiguous, right? And then if it's not unambiguous, you look at what the parties did, and these parties, the co-op accepted, did more than just accept.
That's correct.
Treated the new entity as owner of the unsold shares, right?
Absolutely correct, Your
Board,
Honor. And
everything.
With respect to, I'm sorry. With
And we
respect
have held, even though, I mean, anyone can waive something in a contract. There's no prohibition from waiving anything in a contract. You know, that's a pretty straightforward. And in this case, for 2 years, in not only acquiescence, but affirmative action.
Right, and they took the benefit of the fact that our client.
But what do you do with the no waiver position, which appears, you have it at page 81 in the record, paragraph 26 of the proprietary lease. It's unequivocal that there can be no waiver, and if there's to be a waiver, it must be in writing.
Well, Your Honor, there's case law that we cited in our brief that you can waive even a non-waiver provision, and even Rotblut recognized that that applies in these circumstances because the court considered it. It just found that the facts.
Why should you be permitted to take advantage of a waiver when the operative document says that if there's to be a waiver, it's got to be in writing, and you don't have it in writing?
Your Honor, the apartment corporation knew we were coming in as a holder of unsold shares. They had the guarantee from the sponsor. They consistently treated our client as the holder of unsold shares. They took the benefit for over 2 years. The law is clear that you can
But
affirmatively.
isn't that exactly what this non-waiver provision is directed at? The fact that we let this go on for 2 or 3 years doesn't matter because we never agreed to it in writing.
And, Your Honor, the law is clear, the case law is clear that you can waive such a provision, which is exactly what happened here.
Thank
I
you.
see that my time is up.
Well, the light
We'll
one.
have time on rebuttal, yeah, time. But he'll be back for.
Your Honors, picking up on the waiver issue, Justice Friedman is correct. There is a no waiver clause in the lease, and the conduct that we're talking about, the court is very clear. For a waiver to occur, there has to be a knowing, voluntary, and intentional abandonment of the party's rights. And on this record, I don't think it can be inferred even that such a waiver in fact occurred. And again, as I mentioned earlier, I would refer the court's attention to this court's decision in Rockwood, in which the court made clear that the fact that the cooperative had shown a level of consent to specific transfers that were made by a particular party, in the case who would otherwise qualify as a holder of unsold shares,
You know,
did not.
the problem is you do have a very strong, you can't waive, anti-waiver provision, but then there are these other cases which sort of create this confusion. What you have here is it's not just acquiescence on your part. You actually did affirmatively things to accept this. There's things which you did accepting them as continuing to be the holder of unsold shares. So this is where,
Your Honor,
you know,
to your point, even if that may be the case, this was a case that was decided on summary judgment. And at the very least, there would be an issue of fact as to whether or not the respondent had demonstrated that such a waiver had occurred. Thank you.
In what way? What did you put, I'm sorry.
I'm sorry, go ahead.
In what way? What evidence did you put up to create an issue of fact?
I believe, Your Honor, that the burden would be on.
Well, they've argued, they've said, here's 2 weeks, let me show, here's 2 years. You put me on the board as the sponsor representative. You sent out a notice to the shareholders. So showing, 1, that you knew, 2, that you affirmatively waived. What did you put up to dispute that for that entire 2-year period?
And just to add to my colleague's comments, you also acknowledged and waived all the other obligations that the regular tenant shareholders had in terms of paying flip taxes, in terms of paying sublet fees, all the stuff you now suddenly woke up 2 years later to try.
For an extended period of time. So again, what did you put up in opposition to that showing?
So, Your Honor, I believe that at the time that the co-op had manifested its objection, at that time it had made clear that previous.
No, we're talking about after 2 years. You're talking about at the time that the shares were transferred. What did you put up to show that you didn't affirmatively waive?
Your Honors, I believe that we would have to determine that on a more complete record as opposed to what started as an
This is summary
article.
judgment. If you have it, you should have put it up. Again, I'm going to ask you, what did you put up to disprove that showing?
Your Honor, I believe I would offer to the court the fact that this became a plenary action by virtue of the court having unilaterally changed it, as opposed to originally it was founded as an Article 75. So I believe that a more complete record would have been necessary in order for the parties to be given an opportunity to fully develop whether or not a waiver had in fact occurred.
Thank you very much.
Thank you.
Your Honors, I would point out in response to that, there's been no challenge by the appellant to the procedure that was implemented below. They didn't raise it on this appeal, and it's too late now. With respect to the cross appeal, we would really ask Your Honors, if you affirm, which we believe you should, that you modify the ordering clause that was here, because the lower court included language in the ordering clause that is nowhere in any of the governing documents and was not argued by the parties below. And we'd also ask that you extend the permanent injunction to not just be against the issuance of invoices, but against all the things that a holder of unsold shares is entitled to.
Thank you.
Thank you, Your Honors.
People versus Ruiz.
Good afternoon, Your Honors. Michaela Gelman of the Legal Aid Society for Mr. Daniel Ruiz. This case is about the efficacy of extended periods of community supervision and how extended periods of supervision that have no effect on recidivism are unduly harsh and excessive. Mr. Ruiz has been grappling with mental illness and substance abuse his whole life, precipitated by the sexual and physical abuse that he suffered and endured as a child. Long periods of supervision have not been shown to be effective on recidivism. So the
I
question.
mean, that's a general statement. What is shown that it won't be effective for this defendant? I can show you 10 other studies that say it is. So, sure, studies say different things. I think what I'm trying to say is, what do you have specifically? Do you have a specific person who interviewed this defendant or anything like that that would show that statement is true for this defendant?
Sure, Your Honor. So the records from the 730 proceedings in Mr. Ruiz's case really do bear that out. So in the competency restoration description of how Mr. Ruiz really changed once he was engaged with treatment, once he was engaged with medication, showed a really stark difference between his behavior and conduct before and after the 730 process.
Counsel, just so that I'm clear, he had a history before committing this crime of forcible touching, sexual offenses. Am I correct?
Correct.
Not only that, he's a level 3 SORA offender, correct? That's pretty high. So that while he got a lenient prison sentence of 3 years, 7 years, under these circumstances to monitor that he's doing well, why doesn't that work?
So I'll say a few things, Your Honor. First is the level 3 designation is solely based on the same incidence of forcible touching, which once bumped up to the E felony as the persistent sexual abuse, the conduct is the same. The conduct is all these misdemeanor forcible touchings. And
By the way,
something
he's
that's-
also a second violent offender, correct?
Correct. And something that is detailed in the PPI that was prepared before sentencing in this case is how the forcible touching, even though it is sexual contact, is not always sexually motivated, and that's detailed in the PPI that was prepared by social worker from the Legal Aid Society. What that can be triggered by is the anxiety and conditions of the situation that are all results of Mr. Ruiz's circumstances as a child. And just to answer Your Honor's, the second point of your question, which was about, isn't the 7 years of supervision reasonable? That is still 2 years over the minimum period of supervision in this case. And when, you have literature and research showing that periods over, 2 to 3 years of supervision are not necessary, that 7 years of supervision really does become excessive.
Counsel, weren't all these mitigating factors before the sentencing court? So much so that they structured this plea in the sense, if he had gotten to trial on this as a second violent felony offender, wasn't he facing 4 years in prison and 15 years of post-release supervision? Wasn't this before the sentencing court?
Yes, Your Honor, but that doesn't change this court's inherent power to still reduce sentences that are excessive. Even those that are lawful, even those that are bargained for, this court has the power and authority and does frequently reduce sentences that it recognizes are excessive.
He received the minimum prison sentence here, correct?
Correct. And
He's had a lot of prior convictions. I mean, to have received a post-release supervision 2 years above the minimum hardly seems excessive.
well, again, Your Honor, the prior convictions are this same behavior, this forcible touching, which, as Mr. Ruiz's records bear out, are his risk to the community is so mitigated when he's getting
The
proper treatment, which he is
2015
now.
assault conviction?
So that was Mr. Ruiz's first contact with the criminal justice system, which really coincides exactly with the onset of his mental health conditions when he was 24. Thank you.
Good afternoon, Your Honors, and may it please the court, Katha Murata for the people. Defendant's sentence was fair and appropriate and should not be disturbed on appeal. First, all the factors that defendant references now were well known to the sentencing court, and the judge took them into account when imposing the minimum prison term and the near minimum term of post-release supervision. Furthermore, defendant was convicted of persistent sexual abuse and could have been sentenced to 4 years in prison and up to 15 years of post-release supervision. Here, he received the minimum prison term of 3 years and 7 years of post-release supervision, which was only 2 years above the minimum term. Furthermore, defendant has a lengthy criminal history, particularly with sexual offenses. This is his fourth forcible touching conviction. He has been adjudicated a level 3 offender for the incident offense and for his forcible touching conviction back in November 2018. He also has a second-degree assault conviction from 2015 and an attempted third-degree assault conviction from 2015 as well. Given all this, his criminal history, and that the factors were well known to the court, we believe that the 7-year term is appropriate. If you have no further questions, we ask that you affirm. Thank you.
The 2018 convictions reflected 5 incidents.
I believe the November 2018 was a conviction that covered three separate.
One plea covered 3 incidents and one covered 2 separate incidents.
Yes, the February 2018 covered 2 incidences, and the November 1 covered 3 incidences on 2 separate days. So he received a benefit there as well. Thank you.
Thank you.
Just to quickly respond to this idea of the near minimum PRS, I think it's really important for this court to understand how completely Mr. Ruiz's behavior and his risk to the community changes when he's got the right access to treatment. That is something that is borne out in his 730 records and that we're seeing with Mr. Ruiz in the community today. He's got wraparound services for the first time that he's been asking for, which is also in the 730 exam records, how he's
Well,
been...
I mean, so counsel, isn't continued supervision geared to ensure that he continues to take advantage of those? Otherwise, he can just go out in the community without taking advantage of those services, right? There's nothing we can do to stop him from stopping every single service as soon as he is released.
So it's not the continued supervision that is motivating Mr. Ruiz to continue programming.
Well, how do you know that? You don't know that. I mean, you can say it, but you're not him. He hasn't put in an affidavit that says, regardless of whether or not I am supervised, I will go and continue my treatment, right?
Right. Well, Your Honor, it is what is borne out in his behavior in the community, how he is so engaged with treatment, how in the discussion of his 730 restoration process, he's been asking for it and wanting for it. So this court can see that it is motivated from himself, from Mr. Ruiz.
Thank you.
Thank you.
Hinkson versus New York Presbyterian, and Justice Rosado is recused on that matter.
Good afternoon, Your Honors. May it please the court, Janet Zalian for the city. Hinkson failed to meet her obligation to plead, and she cannot prove a special duty as required to hold the city liable.
So on this record, we know that the original complaint had a conclusory allegation of special duty, but the original bill of particulars and made no mention of how the decedent's grandmother was in any way influenced by the 911 operator, correct?
That's correct.
And for the first time, we have what is styled as a supplemental bill of particulars after the note of issue when you're ready to go to trial, which is really an amended bill of particulars. Yes. And they never sought leave of the court for that, correct?
That's correct, Your Honor.
And now they advance a new theory, at least articulate a little better, that namely that somehow the 911 operator lulled the decedent's grandmother and the decedent's uncle from immediately taking the decedent to the nearest hospitals, correct?
That's their theory.
That's their theory.
Now, the allegation, and this appears actually not so much in the amended bill of particulars that was, as you mentioned, served without leave of court, but in the post-deposition affidavit. Now, putting aside the fact that we argue that's inadmissible, the grandmother doesn't remember the exact words that the dispatcher supposedly said, but even
Right, that affidavit years later, where she at her deposition, she was asked pretty specifically, what did you say? What did the operator say? And she couldn't remember.
And she said, no, I'm afraid.
And then years later, she puts in an affidavit saying, oh yeah, I remember this.
Right, and in addition.
She didn't ever move to supplement her deposition testimony or change her deposition.
She did not.
Yeah,
and there is no basis to admit that feigned issue of fact in that affidavit.
Even if we allowed that, would it be enough?
Excuse me, Your Honor?
Even if we were to consider that affidavit, would it be enough to raise an issue of fact as to special duty?
No, Your Honor, for two reasons. One of them is that, assuming that the dispatcher said something to the effect that an ambulance is on the way, an ambulance was on the way, in fact, two ambulances were, which respondents don't really address in their brief. The ALS ambulance, staffed by paramedics and operated by the city, was, at their estimate at that point, about 12 minutes away, and so a BLS ambulance was dispatched.
And
So
may
that
I just
promise
ask
was
you,
kept.
Counsel, that ambulance is still in the case, the first ambulance, correct?
Yes, of course,
Right.
because it was dispatched
Right.
by 911 and it
Right.
did arrive. It provided some more treatment with the nebulizer that apparently didn't take effect, but then what they also did that was very important was they transported the child downstairs. They got him ready to be served by the paramedics who were arriving in the ALS ambulance.
Well, they were there already, waiting. They were
They
downstairs.
were not there already waiting until, in other words, they were coincided with the transport of the child. So in other words, they wouldn't go up in
Well,
the elevator.
The first ambulance was there already.
The first ambulance
That's,
was
I
there
think,
already. They
right.
were transporting the child. The paramedics wouldn't go up in an elevator and miss the, and they did communicate with the,
My understanding was they couldn't get in, from the record, that the paramedics tried to get in, they didn't get in. Eventually, they met downstairs, in which case the paramedics then proceeded to try and treat the child and get the child into the EMS. Let me ask you something else, Counsel. Were there any representations made by any of the by the EMS crew or the paramedics that they promised to do something or do something that somehow triggered a special duty from their conduct?
No, in fact, they did not communicate. The uncle was upstairs, so he never communicated with them. The grandmother went downstairs with the child and the EMTs and did not communicate with the paramedics at all. They told her to stand on the curb, and then she heard them say, probably to the EMTs, hurry up, bring him this way. And that's all that happened. There was no communication there. So they don't point to any communication that can be an assurance. In addition, their expert did not fault the treatment, fault the fact that the paramedics, when they arrived, the expert noted that the child went into cardiac arrest pretty quickly. So there's no reliance that they can show that they would have done when that ambulance arrived to get the child to the hospital quickly and efficaciously. And I'll
Thank you.
Your Honor.
Thank you very much.
Okay. May it please the court. My name is Laura Gentile, and it is my honor to represent Ebony Hinkson, the mother of Andrew Guadalupe. The special duty was properly pled in the complaint and then supplemented by the Bill of Particulars. The reason it's a supplement and not an amendment is because it was pled in the complaint. There are a number of cases, they're in my brief, and I can...
Why weren't they just conclusory, the special duty? It's not enough to just say there was a special duty. You have to lay out facts to support a special duty. What were the special facts laid out in the complaint itself that supported the existence of a special duty in this case?
My response to that is two. One is that we're a notice pleading state, and
But that's, even in a notice pleading state, one cannot simply say, this is the conclusion, defendant breached the contract, without any facts underlying it. So that gets you nowhere. So let's go to two.
okay,
The
there might actually be three. Two is the supplemental Bill of Particulars is sufficient, and three, there
The
is,
supplemental bill was dependent on it initially being alleged in the complaint,
which it was.
but if we find it wasn't sufficiently alleged in the complaint, then you'd have to make a motion to amend.
That's what a
That
supplement...
doesn't support the argument to the question we're asking, which is whether the complaint does sufficiently allege it.
The complaint as as supplemented, accepting, because you're the judge, accepting your statement that you need a fact-based complaint for a special duty, accepting that, the supplemental bill of particulars expands on the allegations in the complaint, which is
But
exactly
there
how.
aren't any allegations. That's the problem. The only thing that's in the complaint is the city had a special duty. Again, it's not enough to say defendant breached the contract or, you know, you're negligent. You have to have some underlying facts. So this bill of particulars didn't supplement. It started fresh. It added things that were never, ever talked about.
That's what a supplemental bill of particulars does, Judge.
No, that we call that an amended.
Let's
bill
go,
of
let's go
particulars.
further into the merits. So let's say we consider the allegation that the operator said the ambulance is on its way. Why would that create any actionable claim since it's undisputed that the ambulance was on its way? So why would that statement by itself create a special duty?
I'm not sure I understand the question, Judge.
Why would the statement that the ambulance is on its way create a special duty?
That's part of the special duty. The ambulance is on the way, she opens the door, and she doesn't do what she could have done, which she testified to, which was to take 5 minutes to get to the hospital. It was very close for them. Her son was there. He would have picked Andrew up, put him over his shoulder, and gotten him to the hospital.
Wasn't the first ambulance there within 6 minutes?
Yes, but the trigger is about, the reliance trigger is, I'm not gonna go. She could have left immediately when she decided that Andrew.
Advanced life support ambulance arrives at 1:30 p.m. There's contact with the patient at 1:33 p.m. And by 1:49 p.m., they have the decedent at the hospital.
Yes, and he was brain dead by then. The issue is the trigger for not going was that the ambulance 911 operator said, "We're coming."
And they did come.
They did come.
Okay, but we have satisfied special duty. She did not, she relied on them coming. They came.
But what's
and
the
malpractice
breach?
occurred.
What's the breach? That's the thing. How did they breach their special duty? You're saying the special duty that they gave was, we will come, and then they did come.
I don't think the special duty requires a breach. The special duty triggers the exception to the
Only a
immunity.
special duty, if there was any special duty, the only special duty they assumed was that they would come, and they came. It doesn't create an all-expansive special duty.
What the special duty does is it eliminates the immunity which otherwise would exist. And so the duty was.
So once they make one limited promise, it opens it up to all promises?
No, it opens up liability.
What were they supposed to say when they get this call that we need an ambulance? Were they supposed to say, that's nice, and they arrive, but, you know, what are they supposed to say?
That's fine. But the duty is created. The relationship between 911 and the family.
What's special about saying that the ambulance is on the way?
There's nothing special about it, but it creates, it triggers, it satisfies the special duty
Thank you.
obligation.
We understand your argument. Thank you.
Your Honors, I think you understand what the city's position would be in response to the questions. Your questions indicate that. I would just ask if the court has any questions. Thank you, Your Honors.
Thank you.
We ask then that you reverse and dismiss the complaint.
Thank you. People versus Valgian?
May it please the court, David Gagne for the people. The court below made two fundamental errors, either one of which would require reversal. First, the court improperly based its decision on policy objections to the COVID-19 vaccines and vaccine mandates. This was not a minor error. These policy objections directly influenced every single Clayton factor that the court found favored dismissal. As a result, the court's analysis of the Clayton factors would apply to virtually anyone who possessed a forged COVID-19 vaccination card. And indeed, the court dismissed the case as to the other co-defendant.
But mostly you didn't prosecute people who possessed forged COVID-19 cards.
I'm sorry, Your Honor?
But mostly you didn't prosecute people who possessed forged COVID-19.
So in the indictment, there were actually...
Overwhelmingly, you went after almost no one.
So we actually prosecuted 14 individuals who possessed...
Out of the potential hundreds, if not thousands, who may have been walking around with forged cards, correct?
Yes, there were a few hundred that we were able to identify that had possessed these forged COVID-19 vaccination cards. But it is not unusual for the people, when prosecuting large-scale falsification of government paperwork, to have to prioritize whom to prosecute and based on the limited resources that the people have. So in this case, as in other cases of this nature, we prioritized those individuals who fit into certain employment categories.
You know, understanding that the court has a lot of discretion below in making these kind of determinations, why wasn't the factor that this defendant would lose his employment if he was convicted of this enough to satisfy the interest of justice standard, along with the fact that because he wasn't really working with other people, he was an essential worker, but he was working alone, there's no proof that he really harmed anybody.
Okay, so there are a number of responses that I have to that. First, this court has repeatedly held that professional circumstances are not a compelling factor or circumstance showing that a prosecution is unjust. Losing a job, yes, it is unfortunate, but it's a common collateral consequence of a conviction.
You're saying a court is not allowed to consider that when making an interest of justice determination?
It can certainly consider it, but it's not, does not rise to the level of a compelling factor or circumstance that would
None of them are
require-
compelling. It's all put together. And this particular person, and in fact, the only one who you appealed, was the only one who would have a second conviction, right? And even the nurse that you didn't appeal, who was dismissed in the interest of justice, you didn't that would have been her first conviction, probably not as difficult for her. But this guy, it would have been more difficult for her.
In what sense? It would have been more difficult.
In that he would have a second conviction for a relatively minor crime.
Right.
He wasn't the one selling. He didn't make any money off of it. He, in fact, got his vaccines. So, again, that one factor is while not compelling, is certainly one that we can look at.
Well, Your Honor,
To add to what Judge Scarpula says, that, you know, there is all this concern about rehabilitation of defendants. This is a defendant who had a prior criminal record, but he really seemed to have turned his life around, becoming an electrician, being employed by the city as an electrician, and had you prevailed, probably you upset that whole apple cart.
Your Honor, a few things. First of all, this is not someone who showed a great deal of concern about keeping his employment. After getting the forged vaccination card, he then procured a forged doctor's note stating that he had suffered...
I'm not sure there's any evidence to that. That wasn't even part of the indictment.
It wasn't part of the indictment, but it was in the record. And as in a Clayton dismissal, the court can consider both charged and uncharged conduct. We're talking not just about the guilt or evidence of the accused. We're talking about a holistic analysis to determine whether a prosecution was just or
Question
unjust.
is, did the judge abuse his discretion? And clearly the judge was troubled by the fact that this guy turned his life around. This is what we want. This is exactly what we hope will happen. And for a relatively minor, I'm not giving it a short shrift, but certainly the fact that the other person, you're not even appealing the dismissal, it's not a major crime, and that would have had very significant consequences to him.
Well, I'll just say that the legislature certainly considered this to be a very serious offense.
Agreed, but okay.
Thank you.
Thank you.
Good afternoon. Good afternoon, Your Honors. Ronald Zapata with the Office of Appellate Defender for Respondent. The lower court did not abuse its discretion here when it thoroughly considered each of the enumerated Clayton factors and found that it was in furtherance of justice to dismiss this case against respondent, a frontline city worker during the pandemic who got vaccinated before the mandate for workers went into effect. Contrary to the prosecution's argument here, the decision was not based on some broad policy objection.
You know what, though, except, let me read from the decision, you know? Several of the defendants have submitted numerous facts and assertions about the COVID-19 pandemic, the efficacy of the vaccine in general, and policy objections. While many of the arguments are compelling, that's one. Two, other states, such as Florida, refrained from imposing a vaccine mandate. Despite the lack of the mandate, data from the CDC shows there have been less deaths, essentially less deaths in Florida. That's two. I can go on and on and on. It's pretty hard for you to argue that no policy considerations came into effect in this judge's decision. So I think that's a pretty high bar for you. There are other considerations, but clearly this judge had a problem with the vaccine mandate.
Well, the court, however, stated explicitly in Appendix
Yes.
229. it
I
declines-
think all of this is compelling, but anyway.
Well, it's a dicta. It could find it. It was addressing all of the defendant's arguments, saying it's compelling, but I'm not going to consider it
So, counsel,
Why mention it if you're not going to consider it?
because you could see the way the decision is.
Exactly. You could
it
see
goes to, like-
exactly how that judge felt about the mandate.
I would disagree with that. Anyway, but as your honors has
focused
mentioned,
on the other Clayton factors that the court considered. Namely, he was an essential worker. He didn't really harm anyone. There was no evidence that he harmed anyone, et cetera. Correct?
yes, Your Honor, exactly. And you look at the facts of this case, where even when he went to work, he was treated as an unvaccinated person. He still went to work and he was masked. He still had to test for COVID weekly, and so like there was no difference. And then and that was before the vaccine mandate went into effect for city workers.
And would anyone in the public be upset if this guy got off the hook here?
No, Your Honor. They would be more upset about the way the prosecution went about choosing him. This is someone
Well,
who,
or more, I mean, look, I agree with counsel that you can't prosecute everybody and you make decisions like that. But this person, it would have had an incredibly more difficult effect on him than other people who were given probation or the other person who the judge dismissed in the interest of justice. This is what we want people to do, or is turn around their life. And a conviction for something like this could really have sent him way off the road in a way that is not necessary.
I agree, Your Honor. He could lose his job. He could lose his license. He won't have any opportunity for advancement.
He also served as an essential worker during the worst time, correct?
Yes, Your Honor. So he risked his life when we didn't know what was going on and how you could contract this virus. Yes, so if the court agrees to affirm, I would ask that the court also not put his name in, but put his initials, as the lower court had done, to protect him since his case will be sealed. Thank you very much.
I understand Your Honor's concern with the defendant's personal circumstances, but that was not the court's decision. In fact,
Also the nature of the crime that we're talking about.
sure, it is. And just to get back to the point, the court actually found that the defendant's history, character, and condition weighed against dismissal. So it did take that into consideration, and it actually found that that wasn't a compelling factor based on his significant criminal history, and I would add based on the egregious nature of the conduct.
Are we
Doesn't
bound
that
by that
actually-
when we consider it on appeal?
I'm sorry?
Are we bound by what the court below said about that when we consider the issue on appeal?
I think the case law would certainly suggest that. In People versus Keith R. from this court in 2012, the court reversed an interest of justice dismissal, stating that it disagreed with the motion court's assessment. I think we are limited to what was in the court's opinion. I don't think you can just completely disregard
It's
the
like on a
impermissible.
suppression motion, if the court below, or if the point is not made below, we cannot come up with a reason on our own? Are you saying that that's what this is like?
Yes, that's right.
Thank you.
Thank you.
City of New York versus Board of Collective Bargaining.
Good afternoon. May it please the court, Jennifer Lerner on behalf of appellants. Your Honors, the board's decision here infringes on DOT's authority to determine who is fit to captain the Staten Island Ferry, and it was irrational for three main reasons. First, the board did not have a rational basis to find that union animus was the reason for Ferraro's demotion to his permanent
Why
title.
wasn't there a rational basis based on the testimony that other captains who had engaged in the same behavior as this captain did not receive the same treatment, and he was heavily involved in the union in the way that the other captains were not?
So
why wouldn't that be enough to at least create a rational basis for the determination?
Because there were critical differences between how Ferraro was situated and the other people who were seen using their cell phone. This was during discovery when others were reviewed. Ferraro was specifically given a letter of warning and additional training on this exact issue regarding the importance of not being distracted and paying attention at these critical times while you're either arriving or departing, and including passenger transfer.
Counsel, didn't Garvey, one of the head above the complainant here, and another Tory, and there was testimony here that they all thought that was very harsh. There was a reaction that was very harsh, and also there's proximity issues here in terms of when he was advancing as a shop steward, only to find that they were coming down on him. And this is someone, as I understand from the record, and you don't really challenge it, that his evaluations, and this is my words, were all stellar. There's another term they use, it was never less than good or something like that. But he always had good evaluations, and even after the joystick debacle, which created hundreds of thousands of dollars of damage, he was offered a promotion to captain.
So there's a few points there that I'd like to respond to, and I want to make sure I get to all of them. Going backwards, sort of on the issue of a promotion, the only testimony that was given, and even if you credit it, is that he was asked if he was interested in this port captain position. He said no, and that's as far as it went. I don't think it's a fair inference from the record that is being offered a promotion. Second,
Is it a fair inference that he's being considered for it?
I don't think so. I think it's what it is. It's you're being asked. Maybe that's something that they would have explored. And at that time, I mean, look, the initial training.
So, counsel, but I mean, what I hear from you is that you disagree with the hearing officer's credence of the testimony. Not that there wasn't, because there clearly was testimony in support. One, the videos that showed all the other people looking on their phones and not getting disciplined. Two, after the joystick incident, he wasn't punished. Three, he passed his additional training, right? Four, he was offered the promotion. So your argument is with how the hearing officer evaluated that testimony. It's not that there isn't testimony that would show that he was singled out and mistreated. It's just you don't like that testimony or you don't think it's worthy. And on an Article 78, is that our job?
I mean, I fully understand that we have a very deferential standard here. I'm not arguing with that.
And you're not arguing that all that testimony was put in, correct?
However, the testimony, like going back to Justice Schulman's first question, the testimony saying, oh, even Garvey and Tory thought it was over the top. There, the board is apparently crediting someone's hearsay testimony of what they thought someone else thought.
Garvey did not.
Aren't you allowed hearsay in an administration?
Garvey said, oh, I'm sorry.
No,
Garvey didn't discipline him. He testified, I did not discipline him, and I didn't think it was warranted.
Right, on the joystick incident.
Right.
And that's fair.
And
I was
all
just
the
talking.
videos showing all of the other people using their cell phones, correct?
There
So
was
again,
video.
you don't
No,
like the way that the
What I'm trying to
body, let me just finish 1 second, I know, and I promise I'm gonna let you get
Okay.
your statement out. You don't like the way that the evaluator evaluated that testimony, but it's not that the testimony isn't there.
I'm not saying there's no testimony, but I'm trying to explain why it was improper to draw the inference they did from the testimony. So going back to Justice Schulman's first point about talking about what other people thought they viewed, when we have direct testimony from Garvey saying, I was involved in the decision to demote Ferraro and I agreed with it. So to look at someone's hearsay opinion of what someone else thought instead of the actual testimony, I would say that's without a sound basis in reason.
Thank you.
Yeah.
Thank you. You have time, rebuttal.
Thank you.
Thank you. May it please the court, Peter Zweiback for the Board of Collective Bargaining. The court should uphold the decision and order of the Supreme Court below, which held that the Board of Collective Bargaining made a rational decision that the New York City Department of Transportation violated the New York City collective bargaining law by retaliating against the union steward, Christian Ferraro, and other members of the union, that the remedies that the board ordered were rational, supported by board precedent, and appropriate under the law. The board found that the Department of Transportation demoted the union steward in retaliation for his protected union activity, and that the DOT's professed safety concerns were pretextual and a cover for their illegal retaliation.
That's a very fact-based determination, isn't it? It's a very fact-based determination.
The decision is very fact-based, and the decision treats both the issue of whether or not there was hostility, whether or not there was retaliation, whether or not the city rebutted the prima facie case of discrimination, and whether or not the city offered a legitimate business reason. And that
What's your response to the argument that it was irrational because he really was in a different circumstance than the other captains who were using their phone based on his past history and his requirement that he engage in further training?
So his past history, the only past history was the so-called joystick incident, which was, there was testimony that this was the normal way that captains loosened the joystick. It was said that things happen.
He was also, he was made to take additional training.
He was made, he was,
Not because because he knew everything, but because there was a deficiency, right?
no, I think that he had the warning, he was asked to take additional training, but if you look actually at the mid-ags training, what happened was when the Department of Transportation itself reviewed the training and the scores, they determined that the mid-ag scores were not appropriate for the ferry and recalibrated them, at which point Ferraro's score was as good or better than all but one captain. So the record doesn't actually show that there was a deficiency, and there certainly doesn't show that there was any deficiency which could rationally lead to a decision that he was unable to safely
Let
operate
me ask
the
you a
boat.
question, though. Was everyone asked to retrain or just him?
Well, the training was for all captains. He was, previous to the training, asked to also speak to the maritime lawyer, and that he was the only one asked to do that.
So there was something individually about his performance in
There
that.
were in 2017.
Right.
After 2017, we respectfully disagree. We think that the offer from senior port engineer Garvey, who was one of the main supervisors of the ferry, that he might get a promotion to port captain charged with overseeing and enforcing safety regulations, indicates that the ferry in 2018 certainly didn't have any concerns about his ability to follow the safety rules. In addition to which, as has been pointed out in our brief and in your questioning before, in terms of differently situated, the fact of the matter is, the record is absolutely replete with examples of the Department of Transportation knowing
that people were using their cell phone, including when passengers were loading and unloading, including when the boat was so-called on the hooks, including past the buoys where it's supposedly absolutely verboten. And yet, the only person who was ever disciplined for that was the union steward, who was pursuing grievances and who there's lots of testimony about extremely hostile and angry statements. So was he differently situated? Yes, he was the union steward. That was why he was differently situated.
Wasn't there testimony by a George Mahoney, who was an administrator in DOT, that this guy D. Simone was extremely outraged by the grievances that Mr. Ferraro was advancing on behalf of the union members?
Yes.
So there was clear testimony before the board that there was union animus, correct?
Yes, yes, and not only by Mr. DeSimone, who was, may I finish? Who was the main decision maker, but also by Mr. Garvey and also by Mr. DeFont, who were also supervisors.
Thank you.
Thank you.
Good afternoon, Your Honors. I'm Daniel Bright. I represent the union here, the Marine Engineers Beneficial Association. So most of this stuff's been addressed in the briefs, but there's a whole ton of evidence of anti-union hostility resulting in this retaliation. One of them was the cancellation of a radar training course in February 2019, which the city admits was done to retaliate against the union for Christopher Ferraro's filing of a demand for arbitration of his grievances. I mean, in footnote 10 of their brief, they could say they don't disagree with that finding of the Board of Collective Bargaining. They engaged in acts of retaliation, provoked by him insisting on going to arbitration.
They didn't pay for the training, is that it? They didn't pay.
Yeah, so people...
Even though in the past they had?
So if it was your day off and you went to the training...
And that came after the grievance?
That's
non-payment?
Yes, it came about a month after the demand for arbitration of the grievance was filed. There was a phone call from Jim D. Simone, who was a deputy commissioner, called the union headquarters or office in Jersey City to ask to speak to the vice president for the East Coast or Atlantic Coast, Jason Callahan. That in and of itself was bizarre because they had never met or spoken before. He wasn't there. A different union official there took the call and he testified. He took notes during the call and he forwarded his notes in an email the day of the call to the union's president in DC, the general counsel, and other officials because he interpreted what was being said as threats of retaliation. And that phone call was a long, unhinged tirade about Chris Ferraro and his grievances, and he ended the call, which was taken by a union official named Nico Sermonetta, by telling Sermonetta, "Don't you ever call me again and tell your members to stay out of my office." So he was infuriated by this. As far as the disparate treatment goes that Ms. Lerner referred to, there were 5 captains or assistant captains seen using their phones in violation of the written policy, a policy that wasn't enforced ever against anybody except Chris Ferraro after he became shop steward. There were 5 people seen using their phones. Chris Ferraro was suspended for 30 days without pay.
Were any of the other people union officials?
No. And not only that, none of them were active in the union, and not only that, none of them received a warning. So this whole idea that they're not similarly situated, so he got treated differently because he had a warning, well, nobody got a warning except him. You could be seen over and over and again, including one captain in that batch of videos. His name is Brendan Cinque, C-I-N-Q-U-E, because the testimony that's in the record will show this. He was steering the boat while looking at his phone. He didn't get a warning, and management, including Mr. Mahoney, who one of the justices asked about, testified that management, including him, reviewed every bit of video before it was produced to the union. Okay, thank you.
Your Honors, I'd like to briefly address the relief granted here and why it was an abuse of discretion to order reinstatement, even assuming you accept the board's conclusion on the main issue of discrimination. I mean, first, it's important to remember that we're talking about a provisional appointment here. And while we absolutely agree that he was not the DOT could not demote him for an illegal reason.
Even if it's a provisional appointment, we still have to make a determination whether the termination was motivated by anti-union animus. That's the issue before us.
Right, and even if you accept that, which obviously we
We're
disagree
not
with.
making a decision about whether he was properly terminated as a probationary employee. That's not the issue that's before this
Agreed.
court, is it?
Agreed. But if you accept the determination that there was, the reason he was demoted was anti-union animus, the board did not need to order his reinstatement in order to grant the relief. Monetary remedies would be sufficient here. And here is where a provisional appointment is a discretionary appointment. And this is where they are overstepping in taking the DOT's authority away to determine who should captain the ferry. Remember, I mean, even if you find this pretext here, I think on this record, it's very hard to.
Hearing then. I mean, I don't understand why this is the right venue to be making this argument on this appeal. But
Because it's an abuse of discretion to order his reinstatement to this very safety-sensitive position, where someone who is captaining the ferry is responsible for the safety of all the passengers, and DOT has that particular responsibility.
thank you. We will look into that argument. Thank you.
Thank you.
Boliak versus Riley.
Good afternoon. May it please the court. Stephen Bergstein for the plaintiff's appellants. Let me start with the threshold issue of whether hostile work environment claims are subject to the ministerial exception. They are not. And I recognize this court has not addressed
We
this.
know there's a split in the circuits on this very issue, which seems to be the main authority since there doesn't seem to be any New York State court cases exactly on point. Why should we go with the decision of the Ninth Circuit and not the other two circuits?
Because the existence of a hostile work environment is not an inherently religious question. When you read the Supreme Court cases on ministerial exception, they talk about we don't want courts to intrude on personnel and management of the facility.
And
who
you've
gets-
dropped your discrimination straight up, we were fired, we weren't promoted type claims, right? Because those might have been more problematic.
Right, because courts.
This is really, and your parties are not seeking reinstatement, or they're not seeking anything about to even closely or even farther away touching whether someone ministers to the Catholic community in the
Correct.
school,
That's
right?
not the issue. So when we're, there's a huge difference between a hostile work environment and like a tangible adverse employment action case. Hostile environment, there's no religious component. There's no doctrinal intrusion.
You're not asking that the Father Riley be fired. You're not asking any of that. You're just asking on your hostile work environment for money damages, right?
Correct.
So there has nothing to do with him being a minister or anybody being a minister at that point.
That's our argument.
Yep.
So
Okay.
the cases that support us on that issue have a more nuanced approach to ministerial exception than I think the Seventh Circuit or some of the cases that defendants
Well,
are
the
relying on.
Second Circuit really, that case is really about whether the principal is a minister. And that's, I mean, that has, and whether or not, again, that was a firing of a minister case. This is not a firing or hiring or an inappropriate or a
Correct. And
Even you
employment
agree
decision.
that the Supreme Court decisions, the Guadalupe and Hosanna, really focused on termination.
Correct.
And the Supreme Court made it very clear that they were not weighing in on a hostile work environment case, correct?
Correct, or torts. And so when this court is asked to interpret the New York City human rights law and you have an open issue, remember what
This case has been before us before. In fact, I was on the prior version of this appeal. How does that prior decision upholding or authorizing an amended pleading interface with this issue?
Well,
if it does at all.
It does to the extent that the allegations in the pleading were enough to make it a hostile environment, but they didn't assert a ministerial exception defense the first time around. That arose on summary judgment. When we have a New York City human rights law claim where the plaintiff is asking this court to do something that maybe other courts haven't done. Remember the language in Albunio. We construe the city law favorably, broadly in favor of discrimination plaintiffs, to the extent such a construction is reasonably possible. And when you have other cases that support us, obviously it's reasonably possible because federal courts, Court of Appeals, some district courts have supported us on that issue, so it's not outside the realm of possibility that you can sustain a hostile work environment claim even when it arises in the context of a religious school. So if there's no ministerial exception, let me focus on the allegations raised by Boliak.
I mean, is there any question, are they arguing? My understanding was the argument was ministerial exception, you're done. Was there significant argument about whether or not this behavior would have amounted to hostile work environment?
I think they did. Whether it's significant is another story, but they said it's not enough. But remember, city law, we don't have to show severe or pervasive. We only show if you were treated less well, unless the comments were petty slights or trivial inconveniences, which they weren't. And if it's a close call, I think this court has said as such, but the Second Circuit has said it. When it's a close call in a hostile work environment, you let the jury decide whether common mores and standards are enough to permit the finding that the work environment was offensive. I'm not saying this is a close call, but if it is, then you let that issue go to the jury. We know what the comments are on the record. I'm not going to repeat them, but I think you can say that the plaintiffs felt treated less well because of the totality of the work environment, which is the standard, based on what Riley was saying about older teachers.
Thank you.
Thank you.
Good afternoon. May it please the court. There's no dispute in this case that the plaintiffs.
Let me ask you this. Certainly, you know, the courts should not be involved in judging religious determinations at a religious institution. But if someone was to say to you that this really has nothing to do with religious principles or religious beliefs, it deals with inappropriate comments by one person to another person, not touching upon anything dealing with religious matters. So what reason is there to impart the ministerial exception to this?
Well, the case law is clear that the entire employment relationship between a minister and a religious
What case law? The Supreme Court specifically said it is not. So what case law are you talking about?
The Supreme Court specifically said it wasn't deciding torts.
Right. So now you just said it's all covered, but that's not what the Supreme Court said.
Well, the employment cases are not torts. They are employment cases under the New York human rights law, but also...
Those are tort cases. Let's assume that you and I disagree and we think they're tort cases.
Sure. And I also want to just discuss the Ninth Circuit case law. The Ninth Circuit case law that plaintiffs rely on, they're from 1999 and 2004, which was before the Supreme Court ever addressed the ministerial exception. More recently,
The Supreme Court clearly didn't address the hostile work environment issue.
right,
is
the
that
ministerial
correct?
exception.
So the Supreme Court cases don't change whether or not this exception covers the hostile work environment claim or doesn't.
The Supreme Court did say in Our Lady of Guadalupe that the exception requires the authority to select, supervise, and, if necessary, remove a minister. And it also said in particular...
Isn't a hostile work environment a claim what's going on between the employees as opposed to supervision of employees?
Well, between the...
Conduct between employees at the work site?
Well, it's between two ministers, one of whom supervises the other.
I appreciate that you're calling the teachers ministers, but teachers are not ministers, although they're lay teachers being deemed ministers for certain purposes. We're talking about a principal of a school interacting and communicating with the teachers in the school.
The teachers are ministers.
Are teachers. They're teachers. They're not ministers. They're teachers. They may be.
What are you talking? What case has held that a history teacher in a Catholic school, what Supreme Court case said that a history teacher in a Catholic school who's being hostilely treated gets the ministerial exception?
Sure. So first of all, Miss, the
answer.
Our Lady of Guadalupe
Totally does not say that.
fifth and
Doesn't
sixth
say
grade
that.
teachers
In terms
taught-
of termination, in terms of
They
termination.
qualify as ministers, is the point. And I also want to just bring up the Markle case in the Ninth Circuit, which makes clear that the entire employment, I don't think there's any split of authority among the circuits, because the Ninth Circuit in Markle followed the Seventh Circuit in Demkovich and said the entire employment relationship is ecclesiastical and covered by the exception, and cited Demkovich extensively throughout, which was, Demkovich
You're
was
saying
the
that
hostile
these
work.
plaintiffs are ministers?
Absolutely, under Supreme Court, they don't dispute that. Under Supreme Court precedent, Our Lady of Guadalupe, Hassana Tabor, they're absolutely ministers.
All the teachers are ministers. The gym teacher, the history teacher, everybody's a minister?
Well, Boliak was a guidance counselor, and Rhodes was a dean, and
Yes, and they're ministers according to you?
absolutely, absolutely.
who isn't
They don't
in-
dispute this.
No, well,
I don't care what
No, it's, let's say, it's your burden to show your defense, right? So rather, what the plaintiff's dispute or isn't dispute, it's you've got to make out your case.
Sure.
So the question I have to ask you is, you're saying anyone who's hired by a Catholic school is a minister?
No, there's
So
a,
what makes these people ministers as opposed to the cafeteria worker,
They were-
the art teacher? Anyone who interacts with students is a minister?
no, they had responsibilities with respect to forming students in their Catholic faith. They were
A
evaluated.
history teacher had responsibilities to the students?
the
Did you
dean of-
show that?
The dean of men and the
I'm
guidance.
talking about the history teacher. Did you put in paper, in your motion for summary judgment, documents or statements that showed that he I don't know, led prayer or something?
Yes,
What
yes,
did you put
he
in?
was in charge of the altar boys at the school, the history
You
teacher.
don't have to be Catholic to have been a teacher in this school, isn't that so? So
That's
what
correct,
happens,
but-
so what happens to teachers who are not of the Catholic faith?
They're still responsible for forming students in their Catholic faith.
They're
It's
ministers.
absolutely clear in the bylaws, in the code of conduct for the school. They're given letters every year explaining this to them. That's the mission of the school.
Thank
That's what, can I briefly?
No, thank you.
Thank you.
May it please the court, my name is Mark Boydell. I represent Father Michael Riley. I want to start out where my colleague just left off. There was significant submissions to the Supreme Court establishing that these plaintiffs, all three of them, are ministers within the meaning of Morrissey Baruch. That was unchallenged on appeal. In fact, the plaintiffs here have conceded that these are ministers. Now, ministers have different meanings in different contexts.
Counsel, let's concede that. My question is, in this context, because we're talking about neutral behavior that has nothing to do with their functions in fulfilling some of the criteria as teachers in a Catholic school. Just bear with me for a moment. I'm trying to wrap my head around the notion that there's a ministerial exception for a principal consistent and his underlings consistently and constantly in that environment making homophobic, racist, ageist, misogynistic comments on and on to the teachers, about students. I mean, I'm not going into the whole record. I'm trying to understand, you're saying now that Lady of Guadalupe and Hosanna made clear that Principal Riley, your client, and the diocese with the school gets off the hook for this kind of behavior, creating that kind of environment that has nothing to do with dogma or any ecclesiastical law, and you go home.
I disagree with the premise, and let me explain why. There were three reasons why courts throughout the United States have applied the ministerial exception to hostile work environment claims. One is the categorical bar that's set forth in Demkovich, as well as in the 10th Circuit case. The second.
But that hasn't been, let me just interrupt you and say, that has not been endorsed by the Supreme Court. But go ahead, keep going.
You're correct.
So we, right?
As in the majority of circuits that have addressed it, as well as the majority of federal district courts that have addressed the issue,
Okay.
as set forth in my brief.
Right.
More importantly, is applicable to this case, even if you reject the categorical bar. There are indeed religious-based considerations that are
What religious-based, no, let me ask you this. What religious-based consideration is there to permit this principal to call someone a crusty, cunt, vodka-shitting bitch that we don't need? Tell me what religious, what ministerial consideration is there to cover this and to shield that behavior?
I have very little time. Let me try to answer as best as I can. An element, I'd love to have the time to have
No,
this
I just want an
discussion,
answer.
please.
What religion, what Catholic ministerial, what Catholic doctrine is implicated by preventing or punishing by money damages someone from saying that?
Let me go through it. Justice Scarpullo.
Just give me one. What's the? What,
I am. Let me get there. Let me get there, please.
Yes, okay, I'm waiting.
Certainly. Thank you. So, discriminatory animus is an element. What the plaintiffs have conceded and what Father has testified to is that these expressions of animosity, as crude and rude and vulgar as they are, arose from what? Not discriminatory animus, not whatsoever, but rather from animosity as well as disappointment.
That has nothing to do with the ministerial exception, the religious exception. That has nothing to do with Catholic doctrine.
With all due respect,
being angry at someone and cursing them out in the most appalling language has nothing to do with the Catholic Church.
Justice Scarpello, again, let me finish my thought.
Okay, go.
Thank you. So, Father believed that these teachers and this guidance council, the plaintiffs, were not adhering to the standards that were set by a conceitedly religious school, that they weren't fulfilling their Catholic mission, they weren't fulfilling the obligations under their code. And even the plaintiffs concede that that was the motivating factor, together with that personal animosity, in his constant derogatory comments about these others. Not the plaintiffs, by the way.
Thank you. We understand the argument you're making. Thank you.
Okay. Thank you.
Okay,
So I have to ask you, do you concede that the Father calling these people this vile things had to do with his religious ministry?
No.
Are you conceding that?
No.
That's what counsel just told me, that you concede that part of his religious ministry is calling these people what I just said. I don't even want to repeat it.
I'm not conceding it, and I don't think it was, I don't remember that argument in their brief, that was the motivating, but even if it was the motivating factor for this language, you still have a hostile work environment, and you're not intruding on church doctrine when a court reviews whether this creates a hostile work environment. Markle from the Ninth Circuit.
I think counsel's point is that, the ultimate motive for what he was doing had a religious basis, albeit, of course, he used language which clearly doesn't find sanction anyplace. But I think that's the point, that the motivating fact for his conduct has a religious basis.
And do you concede that point? That's what counsel said, that you concede that it had a religious basis.
No.
A religious motivated basis.
No, and a jury could say the real reason he was using this language is because he doesn't like older teachers, and he doesn't like women, and he doesn't like anybody else based on protected characteristics. I have a red light, but let me just...
Oh, thank you.
Thank you.
Thank
All
you
right.
very much. Joseph versus Memorial Hospital.
May it please the court, I am Martin Adams, counsel for appellants. I respectfully request that the branch of the order below that granted respondents motion for partial summary judgment on 23-1.7D and 23-1.30 of the Industrial Code be reversed and the motion be denied, and our cross motion on those claims be granted. Plaintiff respond.
So what was?
Excuse me, there's no real dispute that 1.7D describe, as it applies to that machine room, that the regulation says floor. in the regulation, correct?
It is a floor, but that's not sufficient.
What, it says floor, pathway, there's a number of different building component parts, but 1.7D does say floor.
Yes, it does.
And if it says floor and there's a slipping hazard on the floor, then that industrial code regulation would be triggered, correct?
No, it would not, because first of all, there has to be, according to Rizzuto, the Court of Appeals case, there has to be negligence somewhere within the chain of the project, and that was not shown by a respondent who, as the movement, had the burden of proof. In addition, in order for 1.7D to apply to a slip and fall, there has to be shown by the respondent, who's the movement, that the only way to get to the work site was through this floor or this.
I'm going to ask you a separate question, which doesn't have to do with what you're talking about.
Mm-hmm.
One of your primary arguments is that there was not construction work going on that day, and therefore the labor law doesn't apply in the first instance. If it wasn't construction work going on that day, what was the purpose of the plaintiff, who's an iron worker, being at the premises if it wasn't to do some type of construction work in connection with the construction job?
That's a very good question, and one that the respondent, who had the burden of proof, did not answer. The purpose of the plaintiff's employer being there was
What's your
apparently.
understanding, assuming they don't answer it because he doesn't remember what he was doing that day, what's your position as to what he was doing there that day?
My position as the
What would he be doing there other than construction work?
the purpose of his employer being there, and presumably him being there, was to commission for the Department of Labor a machine, a window washing machine that had already been installed. It was not construction. It was simply.
What do you mean to commission it?
By commissioning is making sure that the Department of Labor gives the okay that this machine can be used.
Wouldn't that be part of construction work?
Not necessarily, because this was already, the machine room was already occupied. Patients had been seen in the building. There was a certificate of occupancy. And again, these are questions that should have been answered by the respondent, who was the movant for purposes of this appeal. We could have said nothing, and the motion still should have been denied because respondent did not meet his burden of proof. Now, we did make opposition. We did cite facts in opposition, and that's another criticism respectfully I have of the trial court, that it basically decided credibility. It said because plaintiff slipped, therefore the Industrial Code 1.7D applied. Respectfully, that's not the purpose of summary judgment, to resolve credibility. And one of the questions which Your Honor asked is, what was going on? Was this construction or was this post-construction? We showed in opposition that it was post-construction. As I say, patients were being seen in the building. The building had been turned over to a Memorial Hospital, the owner. Therefore, I respectfully submit that the trial court reversibly erred when it granted partial summary judgment with respect to the plaintiff, in favor of the plaintiff, and I ask for reversal. I'd be happy to answer any other questions Your Honors have.
Thank you.
Thank you.
May it please the court, my name is Scott Singer, and I represent the plaintiff respondent in this case. The kind of work they were doing is called punch list work, and this court has held that punch list work is within the...
You say in your papers that he was doing punch list work, but the problem with this record is that he doesn't remember what he was doing that day. So how can we make a determination, since you are the movement on summary judgment, that as a matter of law, he was doing punch lists versus doing some other work, since he doesn't remember?
Because there are records going back that this particular employer, that's what they were doing. They were making adjustments.
Doing it when?
In the weeks before the accident, that's what they were doing, because they had to.
But that's a general thing, right? And there's evidence in the record from the defendant that they weren't doing that kind of work. This is just about checking to make sure that the machine that had already been installed was working. And your guy says, I don't know why I was there, which is pretty hard to believe, but okay.
Why is that an issue of fact?
Why is that not an issue of fact?
Because he wasn't the only person there. We had a witness, Tom Cahill. They were all, saying that they were doing what had to be done before this unit could be commissioned. And until it's commissioned, the work isn't done. It's part and parcel of the work.
All right, Mr. Singer, in response to your friend's earlier point to me that you didn't establish on this record negligence along the food chain, so to speak, for it to trickle up in terms of liability under 241-6. On this record, wasn't it established that the plaintiff's supervisor went ahead of him and already went in through into the machine room and pretty much deemed to should have had notice of the water condition, which they acknowledged came from a leak?
Mr. Ueda, who was employed by Turner, it was his practice to go at the beginning of the day to check it out. And he was asked, well, I don't recall on that day, but he said, yeah, it was my practice to go up there every day because when Greg Beach would be working, especially on Saturdays, I wanted to make sure the people were there and everything was set, and he would do it routinely every single day. Whether he couldn't, I can't explain why he couldn't remember, but he couldn't remember that. But yes, it was, that was all you need under Rizzuto to establish notice. It could have been established. This is not something that happened. The first workers that came onto the site that day, and there's one case, DeStefano, where that actually happened. The very first, but this is not what happened there. There were people on the site, and
In fact, he was the last one that was walking among the group that morning, correct?
he had followed the other two. Tom Cahill was immediately before him and witnessed the entire.
What's your response to their challenge to the lighting situation there under that rule?
Well, it's very simple. Cahill testified, in addition to plaintiff, that he couldn't see the water because it was too dark. And in fact, the way the switch was located, you would have to go through the room and essentially to the exit to the roof in order to flip it on. So that would have done no good. The switch was off.
Testified that it wasn't pitch black.
Well, it wasn't pitch black, but it wasn't bright enough for him to see the water.
Did you have an expert who said that?
No, that was based on the observations of Mr. Cahill and the plaintiff himself.
You're basing it on a 241-6, right?
That's a 1.30,
Right.
right? There were two regulations,
Right.
23 1.7D, a slipping hazard, and the 1.30. And I cite case law that says if you can't see what the problem is, then it's too dark. So we sufficiently proved that it was too dark. And I don't think there's any question that ongoing, if you look at the work records, they were performing punch list work. It had to be done. This was stuff that had to be done in order to commission the BMU, and that was what they were there to do. Thank you very much, Your Honors.
Plaintiff
Counsel,
respondent.
what do you say to that? That they were doing there's no dispute that they were doing punchless work.
I'll accept for purposes of this appeal that punch list work was done. What does that mean? The machine had already been constructed. It was now being commissioned. The building was occupied. It was being used for patients. Your Honor asked about the foreman. The foreman had exited, as did two co-workers exiting with no problem at all. Now, respondent says that Cahill said it was dark in there. I have the affidavit.
Who's responsibility for the fact that the light switch wasn't put on?
Sorry, I didn't-
Who's responsible for the fact that the light switch wasn't put on?
That would be whoever was in the room. If light was needed, you turn on the light switch. If light was not needed, you wouldn't. And keep in mind, please, that the door was open and light was coming through the door. There's no dispute about that. There was light in the room where plaintiff was signing papers. The question is, was there sufficient lighting where plaintiff slipped and fell? That's an issue of fact which respondent, with the burden of proof, did not substantiate to the point that allegedly 1.30 was violated. There was no expert testimony. Thank you.
People versus Loeffler.
Good afternoon, Your Honors. Rebecca Martin for Appellate Stanley Loeffler, aka Alex St. Fleur. We are asking that you reduce Mr. St. Fleur's sentence to the minimum in the interest of justice, or anywhere between his current sentence and the minimum that this court would deem appropriate. To start, obviously this was a very serious crime, and no one denies that, including Mr. St. Fleur. However, there's something
The people wanted 10 years on this case, and Judge Caro gave over the people's wishes, gave the defendant 7 years.
Yes, Your Honor, that's correct. And I think that was an acknowledgement of the many mitigating factors that I
So
discussed.
why aren't these mitigating factors taken into account already?
Your Honor, they were taken into account by Judge Caro. However, as I'm sure this court is well aware, as the Court of Appeals recently reaffirmed in Brisbane, you are empowered to review the case again.
Was the defendant 35 or 27 at the time of the crime?
He was 27 or 28. The 35 in the PSR was definitely a miscalculation, you can see, based on his.
Well, assuming that the lower court took into account all the mitigating factors, which it obviously did, then why is this excessive?
Your Honors, we would say that taking those mitigated factors into account, even 7 years, particularly the incarceratory sentence, even 7 years is more than is necessary or appropriate in light of the fact that Mr. St. Fleur was, at this extreme low point, homeless, living on the streets, in fact, sometimes in the subway, and struggling with untreated substance abuse disorder, and drugs clearly contributed very strongly to this offense. In that context, an extra 2 years in prison just doesn't serve any purpose. He will, with 5 years, he is committed to treatment. 5 years in prison already gives him a lot of time to get treatment. And
This crime was particularly heinous, right? He beat the MTA worker in the head so badly. It wasn't,
Yes, Your Honor. It was. Yes, it
he
was
a
incredibly
particularly
serious.
yes. So, and you're
30
saying,
stitches.
right, in that circumstance, that you're saying should be a minimum sentence? And he's not a young man. He's not,
He was 28, so yes, not a youth.
no, he's he's
Not a
he's
new,
sort of
not a
someone-
youth, but he was at this particular low point, and given the contribution of drugs, we would argue that even weighing the severity of the crime, which no one is denying, because of those circumstances, we would think the minimum sentence. And I would also like to note, while we did ask for the minimum on both prison and post-release supervision, to the extent, and I think the prosecution discussed this, to the consent, the concern is that maybe after prison he wouldn't, he would need more post-release supervision. We would certainly take a reduction in prison sentence and not PSR.
Thank you.
Good afternoon. May it please the court. Margaret Crookston for the people. This sentence was fair and appropriate. As your honors noted, it was a very particularly violent crime. The MTA worker suffered over 30 stitches, and his vision was impaired. To the extent that the mitigating circumstances were considered by the court, they were thoroughly interrogated. In the defendant's 730 exams, they went through his mental health history and noted that he was not presenting with any showing of mental illness at that time.
Did he ever express remorse? I didn't see that in the record.
To the extent he expressed remorse, he pled guilty. He said he didn't remember the attack.
And I'm clear in what I said. I said express remorse. I didn't say he didn't take responsibility. He never did, correct?
That is correct.
Doesn't the record show that he resisted treatment?
Yes, in Rikers, he said he didn't need medication. His history was internally contradictory in terms of whether he had.
And those factors of family stability and employment, they were there at the time of this horrendous crime, right?
That is correct, Your Honor. They were there, and to the extent, these were considered, I think that is, as noted, the reason that the judge was willing to give him only 2 years over the minimum when he was facing 25 years of sentencing exposure. If there are no other questions, we ask that you affirm.
Thank you.
Thank you.
Your Honors, I would just say very quickly as to the factors of family support, et cetera. Obviously, those were there at the time, but he was suffering from this untreated substance abuse. He has expressed interest
This
in
was his
treatment.
first felony conviction,
Yes,
correct?
this was his first felony conviction.
The only other thing he had was some arrest in Florida in 2019.
That is correct, Your Honor.
No history of bench warrants, probation revocation, parole revocation, or youthful offender adjudications, correct?
Correct. Yes, and as to the family support, I would just say someone who's coming out of prison, having done all the programming that you can have in prison, is going to be in a different position, and then with the family support then comes in there where they can support continued reintegration. If there are no further questions, I rest on my papers.
Thank you.
Davis versus Port.
Good afternoon, Your Honors. May it please the court, James Chu on behalf of the appellant. Your Honor, I'll be very brief. This appeal involves two issues. One, the trial court erred by refusing to allow an aiding and abetting breach of fiduciary duty claim because this court has already effectively decided that issue. Second, the trial court erred by denying joinder of the SIP4 entities to all causes of action, particularly because the respondent has now asserted a claim or a defense that the profits at issue reside with the SIP4 entities. I'll start with aiding and abetting. This court has already effectively decided this issue back in 2021 when it reinstated the dishonest assistance claim under Cayman law, finding that the claim was sufficiently stated given that the supporting documents allow for the reasonable inference that Cerberus procured or assisted in the alleged breach of fiduciary duties by the Scottish Ray directors. That breach of fiduciary duty is the same predicate that we have asserted underlying the aiding and abetting claim that is proposed in the third amended complaint. The breaches of fiduciary duty there are, in fact, stated with more specificity because of the benefit of discovery that we've had in this case. If you look at our reply brief at pages 16 and 17, we set forth in specificity what those breaches were. We quote line by line from emails that we received in discovery from the respondent, and so the specificity is far greater than the second amended complaint. Justice Reed completely missed it by focusing on the wrong set of breaches of fiduciary duty. What he focused on were breaches of fiduciary duty against named defendants, whereas the breaches of fiduciary duty we're relying on are breaches against non-parties, which is permissible under New York law. Those breaches that Justice Reed relied on were dismissed, and while he paid lip service to this court's decision, he relied on the wrong breaches and summarily dismissed the aiding and abetting claim. We respectfully submit that was error and it was abuse of his discretion because he didn't properly read the allegations in the proposed third amended complaint with the most favorable inference to the movement, as he is required under the liberal standards articulated in this jurisdiction. Secondly, the trial court erred by denying joinder of the SIP4 entities. The SIP4 entities are affiliates of Cerberus Capital. Your Honors, for years, the appellant has been seeking discovery into the interrelationships between Cerberus Capital Management, which is the asset manager, and the SIP4 funds. Recently, in June of 2023, their Cayman Island law expert asserted for the first
didn't all, in the first complaint, didn't all the breach of fiduciary claims were dismissed, right?
So those breaches of fiduciary duty, again, Justice Scarpula, were a different set of breaches of fiduciary duty.
They were all against all the Scottish Ray defendants, right?
Scottish Ray defendants, but the Cerberus defendant, Your Honor, has fought tooth and nail in this case from the beginning to get out of the case. And in fact, they have gotten out of the case. They got out of the case in 2017, and they got back in, they were required to get back into the case by this court in April of 2021. So you're going to...
So you're saying that that others aided Cerberus in the breach of fiduciary duty?
Correct.
And who is that?
Those are non-parties, Jonathan Bloomer, Mr. Adamczyk, among others, and Mr. Chapman. Those are not named defendants. And the discovery has shown that, in fact, there are plausible breaches of fiduciary duty. And again, this court has decided this issue. We've simply expanded on it by putting more detail, putting more meat on the bones. And so therefore, I don't even
We
know
have
what-
not decided whether, I think what we did was basically dismiss all your claims. And now for a third time, you're trying to bring them back in. I think you've got it backwards.
No.
We dismissed all those claims.
No, respectfully.
More than once.
Respectfully, Your Honor, in April 2021, this court reinstated the dishonest assistance claim. And I just quoted from your decision. That is undeniable and indisputable. And they actually don't dispute.
Does Cayman law apply to this case?
I'm sorry?
Does Cayman law apply to this case?
Your Honor, I see my time is up, but I would love to answer that question if I may. The answer is no, because in 2022, this court articulated in Eccles versus Shamrock that the internal affairs doctrine does not apply to aiding and abetting claims. That is unequivocal, notwithstanding.
Except we have law of the case in this case, right? Which we didn't have in those cases. And the law of the case in this case is that Cayman law applies.
But the court is free to disregard the law of the case if there's a change in the law. If we want to speak about law in the
And
case.
the Cayman law, that aiding and abetting breach of fiduciary duty that you are seeking to assert now could not be asserted.
That is correct. If this court decides, admittedly, that Cayman law must apply, then we lose on the aiding and abetting claim. But if we want to speak about law of the case, the only real law of the case that's undeniable here is the fact that this court reinstated the dishonest assistance claim, which is predicated on the same breaches that is predicated in the aiding and abetting claim.
Thank you.
Thank you.
Good afternoon. May it please the court. My name is Judson Brown of Kirkland & Ellis on behalf of the Cerberus defendants. We agree. Justice Reed got it wrong in his decision on the motion to amend. Plaintiff's fourth attempt at filing a complaint over 10 years after the original complaint was filed should have been denied in its entirety, and that's why we filed a cross motion. Plaintiff delayed over 10 years in seeking to add the defendants, the claims, the liability theories, and the damages that they now seek to bring in the third amended complaint. They have offered.
Let me ask you, okay, so as to most of it, I agree. They knew all of this in 2011, and now we're here in 2020-odd. Except to the extent that they say that some parties they didn't find out about until the discovery. What do you say to that?
Patently not true. The plaintiff, Mr. Davis, brings his claims as an assignee of Scottish Ray SRGL's claims.
And Scottish Ray had to have known back in 2011.
100%.
Agree.
Scottish Ray had to know in 2011. And second,
That Bloomer and Chapman were aiding and abetting the breach of fiduciary duty.
what Scottish Ray knew in 2011 was the identity of the Cerberus entities that were involved in these transactions. And thus, when plaintiff filed his original complaint in 2013, he knew all the information he needed to know, both standing in the shoes of SRGL and from his own personal knowledge.
But if I understand him, he's saying that Bloomer and Chapman and a third individual aided in the breach of fiduciary duty. Are you saying that they knew that in 2011?
No, that's not the argument, right? The argument is plaintiff has delayed for over 10 years in seeking to bring claims against the defendants, and these claims that he now seeks to bring. I'll turn to the aiding and abetting in just a moment. But let me say, plaintiff offers no explanation, none, for this over 10-year delay. And under
Well, I just said to you, he said, I didn't know that these parties existed until the end. So yes, he does. I'm asking, and that's what my colleague just asked you. So you can talk about what you want to talk about, but it would be helpful to us if you address that issue.
Yeah, so let me say, under this court's case law, an unexcused delay is sufficient to dismiss or deny the motion.
But if he didn't know about it, then it's not going to be unexcused.
Agree, completely agree. Here, the plaintiff knew the identity of the entity that transacted, that is laid out in our papers. He could have, in 2013, brought a claim against that entity by name, or if he didn't know the name, he could have done exactly what he did in this third amended complaint and sue XYZ Corp, find out the identity of the name of that entity. He did unquestionably know the name of that entity in 2018 when the documents concerning the transaction were produced to him. When he filed his second amended complaint in 2019, did he name that entity? Did he name an XYZ Corp? No, he delayed again. And here, Cerberus is prejudiced by these claims being filed now. Not only is plaintiff seeking extensive discovery despite their representation.
Bloomer isn't even alive anymore.
Exactly. At this point, we are 15 years after the conduct at issue. Two key witnesses are now dead. both Mr. Bloomer, who is implicated by the plaintiff's claims and allegations, and one of the previous named defendants, Mr. Hughes, who was on the special committee who approved this transaction, those witnesses who have really important information, they're no longer alive to offer any testimony. That's what happens when a case drags on, now over 15 years after the conduct at issue. Let me address for just a moment the aiding and abetting claim. The court is exactly correct. Law of this case is that Cayman law applies. In 2014, Justice Sherwood at the trial court did an analysis of the choice of law, and he determined on plaintiff's claim for aiding and abetting fiduciary duty, this is in 2014, Justice Sherwood applied the internal affairs doctrine and determined that Cayman law applies. This court affirmed that application in 2016. In 2017, the Court of Appeals affirmed that. That has been the law of this case for over 11 years now. There is no basis for reversing that. There are no new facts. On page 10 of their reply brief.
And where would you be if New York law applied?
Excuse me?
Where would you be if New York law applied?
Well, if New York law applied, then the aiding and abetting claim would be permissible, except it is
the delay. That doesn't deal with the delay.
Exactly. The delay, everything should be dismissed. The aiding and abetting, breach of fiduciary duty claim.
And you're saying it's duplicative of?
So the aiding and abetting breach of fiduciary duty claim is duplicative of the dishonest assistance claim. Under the law, the test for whether claims are duplicative is whether the theories, the facts, and the damages are the same. Plaintiff concedes that the facts are the same between the dishonest assistance and aiding and abetting fiduciary duty claim. Plaintiff just simply argues, oh no, the damages aren't the same. But what does he identify as the difference in damages? Just that the interest rate for pre- and post-judgment interest in New York is different than the interest rate under Cayman law. But interest isn't damages. Thank you.
Your Honor, just very quickly, because there's so much to respond to, but the most important is this concept of delay, which I have to point out is actually misleading. This case, yes, was filed in 2011, but for purposes of this respondent, this is not a 12-year-old case. This is a 4-year-old case. Mr. Davis was not the assignee of Scottish Ray in 2013 when this case was filed.
That doesn't matter. The case law, the legal principle is that this person is charged with the knowledge back from 2011.
But when they're talking,
I mean, that's the way it is. Otherwise, and in 2025, you could buy the claim.
Correct. But as far as the argument goes with respect to prejudice and timing, the case was reinstated against Cerberus. They fought. So if they want to talk about delay, the delay was due to their exercise of their legal rights. They were allowed to move to dismiss, but they also resisted discovery, which is extensively discussed in the record below. So you can't argue delay, cause the delay, and then cry prejudice. Thank you, Your Honors.
Your Honors, Cerberus did not cause any delay. What's really going on here is that in the summer of 2023, Mr. Davis learned, pursuant to Cayman legal experts, that his theory of damages was not available to him through the defendant that he sued in the case. And so now Mr. Davis is seeking a do-over. But that is not excuse for delay. Justice Reed's decision should be reversed. The motion to amend should be denied. Thank you.
Thank you.
Thank you.